Good afternoon. Welcome. Our session is Avoiding Legal Landmines, a review of recent cyber cases. I'm Julie Bowen. I'm incredibly fortunate to be sharing this stage with Rick Aldrich and with Arvind Swaminathan. I would love for you to read their very impressive bios. We're not going to take the time to discuss those, but suffice it to say, we have a lot of knowledge and experience sitting here to my right and further right. Professor Aldrich brings a lot of scholarly experience, and Arvind, with the law firm Orrick, has been involved in a lot of cases either that you will hear about or very similar, and so he is going to bring a wealth of experience. As we go through cases, we would love to take questions, so if you have a question, shout or come over. There's a mic over here to my right and to my left. No good session would begin without a disclaimer. And would just like to remind everyone that we are not representing our companies and firms, but ourselves, but we hope you will learn quite a lot about what's happening in the landscape, and 23, 24 have definitely been very interesting in the cyber case realm. Now I will turn it over to Professor Aldrich.
Thank you. So the theme of this year's RSAC is the art of the possible. And so we wanted to just show how our session links into that. Otto Bismarck made the popular quotation, "Politics is the art of the possible," and we believe that law is the expression of politics. So what our session will talk about is how law may limit or enlarge the art of the possible. And to some extent, we'll talk about how some of the cases and some of the technology actually indicates that code may increasingly become law, and how technicians can kind of control how the law is implemented and interpreted based on how they design the technology. So some interesting things there. The first case I'd like to discuss, and again, as we indicated, we welcome questions, so just raise your hand and then go up to one of the mics. This is being recorded, so we just want to make sure we capture your question. But this is a Merck versus Ace American Insurance. Cyber insurance has had a lot of cases that have spouted up recently, and this is one of the more important ones. It is kind of a landmark case, so I wanted to make sure you were familiar with it. In this case, Merck got hit by the NotPetya virus. NotPetya, as you may recall, came out in like 2017, so you can see these cases don't get settled quickly. But after they got hit, they suffered about $1.4 billion in damage, and 40,000 of their computers were completely bricked. So fortunately, they had an insurance policy for $1.75 billion. So they indicated their desire to file a claim. They filed a claim under a provision that covers losses based on attacks against your software, and resulting losses in data or hardware as well. So based on that particular provision, they said, we'd like $1.4 billion based on what we suffered. The insurance company came back and said, well, unfortunately, we have another provision that precludes any claim that is the result of a hostile or warlike action. And at the time, the United States, the United Kingdom, Australia, and several other countries, their intelligence agencies said that they believed they had a strong confidence or high confidence in the fact that this NotPetya was the result of a Russian attack. It was developed as a tool they believed to be used against Ukraine, and Ukraine indeed suffered some damage from this attack. But it was not a focused attack, unfortunately, the way they wrote the software, the malware. And so it ended up spreading around the world and causing about $10 billion in damage around the world. So the question that's raised by this case is, does an insurer's hostile or warlike action exclusion deny a claim resulting from NotPetya if, in fact, NotPetya was used in a war setting and it happens to create a lot of collateral damage? So how many think that it should? Should the claim be denied? Raise your hand. How many think it should not? Okay, very good.
No carriers in this room.
Yeah, exactly. Well, it wasn't quite so settled, and actually some people believe that it would not rule today, but in fact, this particular court did come down believe that the term warlike or hostile action originally was included in these contracts under the understanding that it would involve armed force of a nation state, and that it was not envisioned at the time that it was put in the contracts that it would extend to cyber attacks, and for the insurers to just continue to use the same language, but to infer that a broader understanding of it should follow was not appropriate. So that's why they ruled that this was not the exclusion would not apply. So in other words, they get the $1.4 billion. Now, ACE did threaten to appeal this decision, and just hours before the decision was going to be heard, oral argument before the New Jersey Supreme Court, it was settled. So we do have the settlement. We don't know the exact amount, because usually when they settle, they're not allowed to disclose. But presumably, they just both decided that after 7 years, this was time to call it quits and settle for whatever they both deemed appropriate. I will say it does raise a lot of concerns, and this is, I think, what your takeaways are. One, insurers are not going to sit on their hands on this. So, they've already been changing their language to specifically include cyber attacks in their hostile or warlike action exemptions. Some of them are also creating separate riders for terrorist attacks, and they're making you basically sign saying, I understand this does not include terrorist attacks either unless I pay for an extra rider, etc. So there are specific activities taking place on this, and because of the level of damages they had to pay out on this, rates skyrocketed shortly after this. Unfortunately, they skyrocketed so high, some people said, well, I guess we'll do without insurance. And so the market cratered a little bit. So when it softened like that, they started bringing their rates down a little bit. So the unfortunate thing is I think insurers just don't really have a good statistical basis on which to really measure what the likelihood is of a catastrophic attack like this. There has been some indication at the federal, national level within the United States that maybe the federal government would have to step in and kind of provide a backstop so that people will feel confident in running cyber, running their businesses based on their computer programs and hardware without the fear that they may not be covered in some type of catastrophic event. Whether that will ever come to pass, that the United States would step in as a backstop or not, unclear, but that's at least being reviewed. It does make for some interesting spin-offs too, though. What do you think the result would be if Russia attacked Starlink through a cyber attack? How many of you think that would be excluded by the warlike provisions? Okay, so I'm getting a lot more people who think that would be. Technically, the way that this language was written, they basically said cyber was not envisioned in this. So even though in this case, Merck was kind of a collateral damage, the language of the case seems to suggest that maybe even if they were direct, as long as it was not kinetic attack, but a cyber attack, that maybe it still wouldn't apply. I think in that case, they may come out differently. You never know. The language may just have been unintentionally overbroad in this case. But you also look at Microsoft. Microsoft is in Ukraine providing a lot of the details, et cetera, on how to defend their country. So, do they create a situation there? So I think there's a lot of issues here, and I'm getting the time that's all I have to spend on this case. The next case is the general AI case. So AI, there's not a whole lot of case law on this yet, but there are a lot of lawsuits that are pending, so we probably should have more information soon. In this particular case, some coders who posted some of their code on GitHub complained in a lawsuit that Microsoft, through the ChatGPT and GitHub, they basically sucked everything up from GitHub, and then now these coders believe that if you input parts of their code, you will get other parts back. So they're saying, well, wait a minute, we had protection on this. Now, if you look at the GitHub terms of service, they actually, if they put it in a public repository, they agree that people are allowed to use it and under certain restrictions. And there's about 11 different restrictions they can put on it, 11 different types of intellectual property protections. Actually, there's 13. 2 of them say, well, I'm not exerting any IP rights in this. 11 of them are variations on it. Almost all of them involve a requirement that you post the license, that you post the owner of the copyright, and that it be limited to what is permitted by the license. In this particular case, what they were claiming is that when ChatGPT basically ingested all this data, that they basically ripped off the copyright license information. So if you put in a prompt into ChatGPT and ask it to code something for you, what you will get back is potentially something from GitHub, but it won't have the attribution aligned with it, which is required under this particular provision. So that was the basis upon which they sued. Now, some of you may be saying, who is this guy, Doe? Doe is just a legal term for anonymous. Some might be asking, why are they having to sue anonymously in this, or pseudonymously, I should say, pseudonymously in this type of case? Supposedly they were receiving a lot of threats for bringing this issue up. So I guess there must be a lot of people who support AI and don't want it to be crushed out of the gates. So the court actually allowed them to proceed pseudonymously. There were several Does involved, and certain ones refused to provide even the code that was allegedly taken from them. So in those cases, those particular complaints were dismissed. And over time, most of the complaints have been dismissed. One of the few that remained is this 1202B, which prohibits the intentional removal of certain copyright management information, and that includes author's name, copyright owner, terms of use. So how many of you think that the production of code via Microsoft's Copilot or GitHub, how many of you think that violates this particular provision of the digital millennial copyright? How many think it does not? Okay, we got a more mixed view on this one. The court's still out. They dismissed one of the earlier claims that it was a false CMI because there was really no CMI. And as this case has progressed, they eventually dismissed the 1202B provision as well. The reason is because that particular provision requires that the CMI, that copyright management information, be included on exact copies. And the way they applied their case, they said if you put in certain prompts, you will not usually get back our exact code. There'll be very minor modifications, but it's functionally equivalent or almost identical. And the court said, well, if that's your pleading, then you're basically saying it's not exact. And if you're saying it's not exact, then you lose under that provision. So what the court said is, we're going to dismiss that case, that complaint, but we will allow you to amend your complaint. So it's unclear whether they'll be able to amend it and keep this alive or not. I think this does create a lot of issues, though. As many of you probably are aware, the New York Times has sued under a copyright claim as well, claiming that if they put in about a third of one of their articles and asked ChatGPT to complete the article, that it would complete it almost identically, almost verbatim to what was actually appeared in the New York Times. So they were claiming that was a copyright violation. Some are claiming maybe not a copyright violation, just to ingest the data because that may be considered a fair use. Some are claiming that even when you push it out, it may not be. It may be a transformative use or it may be a fair use. But these are all questions that are still kind of bouncing around in the courts. So this is one of the few cases we actually had a decision, at least some preliminary decisions on. But I think the other takeaway you should have from this, if you're not actually in the AI business, is to what extent does your company use AI? And are you a large enough company that someone might want to sue you and say that your use of this AI product was itself a copyright violation because you knew or should have known that this was how they did this particular AI, and that therefore you as a deep-pocketed defendant should also be liable. So, again, get with your legal departments, kind of mull this over to see what risk you may have of your own if you use certain AI, if you aren't fully aware of how exactly it's being used. And the next case relates to geofence warrants. Geofence warrants, in case you're not familiar, are basically identified areas on a grid which law enforcement identifies for the purpose of finding out who is within that area with a cell phone, a cellular watch, or something similar. Or any type of GPS device, basically. It generally has to be tied in somehow to Google, but you don't have to have an Android, although that certainly helps. If you use Google Maps or if you use any other Google app, as long as you haven't opted out. They say you have to opt in. I don't know exactly, maybe I opted in sometime. I don't actually remember opting in, but apparently if you do opt in, then of course they can do it. And if you don't opt out, then obviously they have your data. There were some people in the Capitol riot who chose to opt out right after they participated in that riot. And law enforcement did ask for geolocation information in that case, and they got quite a bit. And then Google actually volunteered, oh yeah, and by the way, these people opted to have their data deleted on that same day. Did you want their data as well? Because they were at the Capitol. And they said, oh yeah, why don't you give us that too? So if you're going to opt out early. But in this particular case, what happened was an individual was killed in the parking lot of a bank. And after he was killed, the law enforcement came in and they looked at the bank's videotape. The bank's videotape showed that shortly after he entered the parking lot, a gray vehicle pulled in and then a red vehicle. The person in the red vehicle got out and went and talked to the guy in the gray vehicle. Then he walked as the gray vehicle slowly approached the victim. The driver of the gray vehicle shot the victim, dead. He fled immediately. The guy in the red vehicle grabbed the backpack, put it in his car, and he sped away. The video surveillance was not detailed enough to actually pick out license plates. So what law enforcement did is they found out more about why was this guy at this bank, and they found out that he worked for his uncle who managed gas stations, and that his job was to go to each gas station, pick up their cash receipts, and then deliver them to the bank. So they determined what his path was that day. He started out at his apartment complex, then he went to 4 different gas stations, and then he went to the bank. So they put in a geolocation request to Google saying, we want all people, all devices that were within a certain radius of the apartment complex and each of these gas stations. Now the way they did it is they said, apartment complex, we'll put a little dot in the middle, do a 100-meter radius around the apartment complex. Then this gas station, do a 75-meter radius around it. This one, 50-meter radius around it. This one of them they did a rectangle instead, but in most cases they did a circle. So what happened though is in some cases, like the 100 meters around the apartment complex, that covers everyone in the apartment complex, plus all the cars that come and go to the apartment complex. So the question that gets raised by this is, does a geofence warrant for 6 locations covering the 5 to 6 city blocks, this was quite a few acres of area, does that violate the 4th Amendment? And the 4th Amendment, again, is protected against unreasonable searches and seizures. How many think it does? Okay, how many think it does not? Okay, mixed view on this one too. Okay, so the court held it does. And I will say the courts have gone on both directions on this, but it's instructive to see why the court went in this particular case. Basically what they held was that Google requires a warrant. Okay, this is an interesting thing because it's unclear whether federal law requires a warrant for this type of information, but Google said if you want it from us, we're only going to give it to you if you have a warrant. And by the way, we have a 3-step process you're going to have to jump through or else we won't give it to you either. So in a way, Google was able to establish some contours here that everyone followed because Google had all the data. And what they do is the first step is tell us everyone who's within your geofence. So he had 6 geofences. They tried to pull all the data for all those people. In this particular case, the Google employee said, one of these locations, I'm having to pull a ton of devices, and I don't think it's really fair. Can you narrow the scope of your search at all? And the police officer said, well, I'm really only interested in people who were at least at 2 of these sites, because otherwise they're not going to be the person. I really can't tell. So she said, okay, I'll narrow it down to that. When she narrowed it down to just 2 sites each, at least, they only came up with 8 devices. And 1 device had been at 4 of the sites, and 1 device had been at 3 of the sites. So they focused on those 2 people, and it turns out that was the driver of the gray car and the red car. So based on that, they prosecuted them for robbery and murder. They were convicted under a guilty plea that was made pursuant to a reservation of their right to raise the 4th Amendment claim. They raised it in court. They lost, so they reserved the right to raise it after they pled guilty. They got 25 years and 15 years. On appeal, though, the court said it did not meet the requirements. And the reason they said is because it covers too many innocent people. You should have not done a circle, which is massive. You should have done a very narrow area, maybe the parking lot only of a narrower thing. Now, this can be tricky because gas stations are in areas where lots of people are going to come and go. You know, it's easiest, the cases where they've won and where they've upheld these geofence warrants generally tend to be, it happened late at night in this deserted building, far from town. You know, there's only one person that went into that area. People don't get as riled about that. But you pick something in the middle of the city where tons of innocent vehicles are coming and going, the courts get a little bit more nervous about it. Now, there are some who push back on this whole analysis saying, well, it's not the government that's looking at all these people. Yeah, there's maybe billions of people, but the fact is, or, you know, in their database, but the fact is the government's not looking at any of that. Google's looking at it. And the protection of the Fourth Amendment is as against the government. So why would this matter? In any event, it may not matter at all, because as you see down below, Google got tired of responding to all these geofence warrants. They were getting 20,000 a year. And so they said, okay, enough. We're going to change our code so that we don't store it in one central location on our Google Cloud anymore. We're going to store it on your own devices. So the only way the government can find out where your device was is they would have to actually get search warrants for each of your devices. That kind of undoes things. So now what law enforcement is doing is they're doing keyword searches. So if you type Google searches into your computer and they're relevant to a particular case, then they might get it that way. There was a case where some people got killed by a massive fire. They couldn't figure out any linkage to why people wanted to kill this family. And so they did this Google keyword search and they were able to find the people that way. Now there are questions about that as well, but so far the Colorado Supreme Court actually upheld that. They upheld it on narrow grounds. The lower court was a very broad grounds. The Colorado court actually said they didn't think, arguendo, they thought it was probably not legit, but they were going to uphold it on basically they followed the rules, so they said they could do it in this case, but future cases, beware. So, how's my time? Okay, good. Okay, so are there any questions about any of these three cases before I pass it off onto my colleague? Yes? Yes.
So now they don't even need to be involved.
Well, they don't need to be involved. They can't be involved anymore because they're not storing it centrally. So they're storing it on your phones in an area they can't get to. So, and this is why I said at the beginning, code is law. By making this technical change, they've now prevented the government from getting data from them. The government can serve warrants on them still, but they're going to be like, can't get to it. Sorry, wish we could, can't though. So there's a technical way that Google could change the law effectively by changing their code. Okay. Thank you very much. Any other questions? Yes.
Can't they still get that information from the cellular providers?
Yes.
So if the cell towers are still doing the ad tech data, can still answer that question. It's just Google's not doing it anymore.
Right.
Yeah. And there's a different case on cell site location information. So the Supreme Court has held cell site location information may not be obtainable in certain cases because depending on how long you get it for. Like if you say, I want every place this particular phone moved over the past 30 days, the courts have said, no, you can't do that because that's basically like a general warrant. It's just like, I want to know, if the guy created any crimes. They've kind of, in some other cases, the Jones case, they actually said, look, you could put a tracking device on someone and follow them wherever they went. But in the old days, you would have had to have, police officers stationed at every corner following them, and that would be so expensive and so costly that you would only do it in the most expensive cases. Throwing a GPS tracker on a device is cheap, and you can basically look at whatever. And even CSI, cell site location information, CSLI, dirt cheap. You can do it whenever. So they said, we're going to have to pull back to preserve what they believe the original intenders were trying to protect by the Fourth Amendment.
Okay, I'm taking the fifth on that because I was a former federal prosecutor. Garbage. Okay, so I'm going to talk about three different cases. I'm going to start with Joe's case. So full disclosure, Joe is my client. So we represent him on his appeal of his conviction. So most of you, anybody not know the facts of this case? Okay, so I won't spend a lot of time. Okay, simple description of it was Joe Sullivan was the CSO at Uber. They had a data breach that was being investigated by the FTC. They had a second security event, where some folks had stolen data and they used their bug bounty program to go ahead and reclaim the data. They had a confidentiality agreement. It wasn't disclosed to the FTC, and the FTC, the DOJ came forward and said, I think this is obstruction. I think what you've basically done is concealed information that's within the scope of the FTC's investigation, and we think this is misprision of felony. That charge is hardly ever brought in the United States anymore, and misprision basically says you're not allowed to actively conceal a federal crime, right? And so what they said was, hey, these guys had hacked into Uber. By not disclosing that, you've actively concealed a federal crime. So Joe went to trial on this case back in a couple years ago. He was sentenced, actually a week tomorrow it was his sentence. And when he was sentenced, the judge gave him 0 time. So notwithstanding that, Joe hired us, and so we're now actually litigating his appeal. And so there's actually a couple interesting questions on appeal that we're talking about. I'm not going to talk about obstruction. It's only a case that lawyers will really care about, although what will be really interesting is that the argument that we are essentially making is that there has to be a nexus between the FTC's investigation and the obstruction charge. I'll leave that for a different day. What I do want to talk about a little bit is the misprision of felony charge, because the idea here was that these guys had come into Uber, they had stolen data, and through their bug bounty program, the company says, you know what, I get it, but it's okay. We would like to have you participate in the bug bounty program, and they basically said, we're after the fact authorizing you to do it. So the question is, can you actually do that, right? Now this is fundamental to every bug bounty program that exists, because as you all know, right, sometimes white hats, gray hats, whatever you want to call them, they get access and they come forward and say, hey, I got access, here's proof of concept. And then you say, yeah, that's okay, we'll pay you, keep it quiet, we'll go fix it, and life goes on. And the bug bounty programs are a supremely important part of our ecosystem, right? Lots of companies today, hundreds of thousands of companies, leverage bug bounty programs in all different shapes. And they base it on this notion, on this fundamental notion that I can authorize your access after the fact. Section 1030, which is the Computer Fraud and Abuse Act, says nothing about that. It doesn't say that your authorization for access has to be before or after. All it says, right, all it says is unauthorized access to a computer or protected computer is a federal crime. So the question in Joe's case is, can you do it afterwards? This became a critical question to the jury. This is something you don't really see often. The jury asked a question, and in trials, the parties go ahead, they make their openings, they put on evidence, you get closing, and then the juries go back and deliberate. But sometimes they have a question, and they bring forward their question, the judge reads it out, the lawyers argue about how to answer the question, and the judge tries to answer the question and send them back. And the question that the jury wanted to know was whether or not Uber had the legal right to extend authorization after it occurred. Because they understood what the problem was in the government's case. I'm an advocate now for 30 seconds. They understood the problem in the government's case, which was they said it was okay afterwards, so what's the problem here? Well, the judge did not answer that question. He refused to answer the question and just said, go back and look at what are called the jury instructions. The jury instructions lay out the elements of a crime, and he sent them back to go look at the jury instructions, and they came back with a guilty conviction the day later. So where we are right now is we filed Joe's brief in October. It was supported by a number of amicus briefs. The government has taken a really long time to respond. They finally filed their opposition brief, right, saying, no, the convictions should stay, about 4 weeks ago, 3 or 4 weeks ago. Our reply is scheduled to be filed in about 5 weeks or so. But this case is important. Forget personal liability of CISOs, which is a completely different conversation I will talk about one other time. This case is really important because it has real implications for how bug bounty programs work. Because if the court says, no, you can't do authorization after the fact, we got a problem. We have a huge problem. Every security researcher who's out there, whether they're on the bug bounty platform or they're not on the bug bounty platform, all the white hats, all the gray hats who are trying to do crowdsourced research and find vulnerabilities and help us have got a really big problem. Because every time, it's a goddamn federal crime. So this case has huge implications for how we actually manage security and particularly bug bounty programs specifically. Okay. Any questions about that? Yeah.
Yeah, just, so the person ultimately, I mean, Joe Sullivan is the one that was ultimately being brought up on charges, even though this person that he authorized after the fact actually did the hack.
They pled guilty. Yeah.
Compromised the information.
Right.
So what does Joe respond, I mean, what's the suit for Joe?
Yeah. How does this connect to Joe at all? Yeah. So it's a great question. This is where this gets complicated, but here's what I will tell you. So the underlying individual who actually did this act pled guilty. And in another part of our brief is an argument that the government offered that guilty plea as evidence that this was an actual crime, right? Which, roll your eyes all you want. I rolled my eyes. They went in the back of my head and out the back, right? So I agree. What we've argued in the brief is that was incredibly prejudicial to say that, like, just because some dude pled guilty, like, that should be evidence of the fact that it's a crime. It basically takes the question out of the jury's hand. But your questions are really, so that's the first part of your question. The second part is, like, how does this matter to Joe? Misprision of felony is a crime if you actively conceal a crime. So the predicate is, was the underlying activity by, call them what you want, researcher, a crime or not? If it's not a crime, I can't be active of concealing anything, right? So the question you ask is a really good one. The reason it implicates Joe is because they said he actively concealed a crime. If it ain't a crime to begin with, Joe ain't guilty of shit, right? Okay, I'm an advocate, sorry. Okay, second one is, here we go. Okay, consent decrees against CEO. So this is the matter of Drizzly. And in Drizzly, as some of you remember, I'll give you the short form of this version was, Drizzly was hacked, right? And a bunch of data was stolen from Drizzly. So the question that presented in Drizzly is, it's really not a can, although I said it's like, can the FTC use its power? It's, will they do it? And here's what the FTC did. So the Drizzly platform, as you all know, like, enables people who are adults to buy alcohol online and have it delivered to their home. Drizzly had a breach in July of 2020, resulting in the exfiltration of about 2.5 million records of personal information for individuals. The individual gained access through a GitHub repository, stole credentials, used them to get access to tables and relational databases, and stole all the data, okay? The FTC decides it's going to do an investigation and enter into a consent decree. And so they do an investigation, and what they ultimately did was they entered into consent decree. So here's how the FTC works. The FTC, as a general matter in consumer protection, can't fine you out of the gate. They can fine you the second time around when you violate the first consent decree, but they can't really fine you on the first one. So the Facebook $5 billion judgment, that's because they were already under a consent decree. They then are alleged to violate that consent decree, and it carries like a penalty of almost $40,000 per violation. So really big stakes. In other words, first time you kind of get a slap on the wrist, and the second time you get a lot of money thrown at you. But consent decrees, what they require is they require, or they allow the FTC to say, you have agreed that you have done some things that are wrong. I'm going to enter a consent decree with you. I get to audit you for 10 years or 20 years to make sure you do not do what you previously did, okay? So it's a huge amount of power the FTC has. So the FTC enters into a consent decree with Drizzly and who? The CEO, right? What that means for the CEO, Corey Relis, is that wherever he goes for the next 10 years, that consent decree follows him. I'm going to say that again. CEO of Drizzly was like, I'm going to go look for another job. This one sucks. So he goes over here and he tries to apply for a job, and what happens? This consent decree seems to be following him everywhere he goes, and his new employer would be subject to that. What's that mean for Corey? No one's going to hire that guy, right? We've spent our whole careers trying to keep clients out of an FTC consent decree. Why would I hire this guy? It's career suicide, right? But that's how that case gets solved, right? And so the important thing about that is that the FTC has taken a slightly different tack at enforcement actions. Because what's true? Companies pay big fines all day long. And so they've gone back to something called the Yates Memo in the Obama administration, where the DOJ said, if you want to change corporate behavior, hold individuals accountable. Put a butt in a seat and watch people change. And the DAG was just at the White Collar Conference 6 weeks ago here in San Francisco, I think, and said, we have not abandoned that policy. And it's not just the DOJ that cares about that. The FTC, the state AGs, NYDFS, they all care, SEC, all care about this now. And the way that they've decided they're going to affect change is by holding individuals responsible, right? So, and now, if I tell you the last 2 consent decree drafts I've seen from the FTC and enforcement actions, what have I seen? An individual named. Now, strategically, you can bargain that away, you can resolve it without that, but you're going to have to go through some gymnastics, right? But the bottom line is that the FTC has got their sights not just on the company, and by the way, not on the CISO necessarily, on the CEO, right? Because that's how you're going to affect change in corporate America, is what the government has decided. So we're now going to hold personal individuals liable, right, in some sense, for what their company has or has not done. So the stakes are much higher. So we get to Tim's case, right? Yeah, sorry. No. So it's a settlement, right? No one's really litigating with the FTC on a consent decree. And what I mean by that is, if the FTC says you violated Section 5 of the FTC Act, you could go to court and deal with it. There's a process, I won't get into it, but you could actually litigate it, and you could determine whether or not you're liable or not. So nobody's litigating those, they're settling them, so it's essentially an agreement, right? So it's a great question. It's not as if the court has said, yes, the FTC can do this. This is like regulation by fiat, right? They're saying, you did something wrong and I can prove it, so you want to go through hell with me or you want to take a settlement? And if you go through hell with me, it's going to be a lot worse, right? And so they're using their power, right, in a way to drive settlements. And most things with the FTC settle, right? Or they agree not to proceed with their enforcement action. So it's a great question. It's not an issue of whether the court has said it's okay or not. The FTC is doing it, right? Just the way that the SEC was trying to force companies to disclose material incidents before they passed the rule this past December, by essentially saying, look, there's a theory over here, see Yahoo. Look, there's a theory over here, see Facebook, right? And so instead of actually legislating or changing things by rule, they did it essentially by fiat. It's a great question. Other ones on that? Before I get to Tim? Okay. I don't represent Tim. Very nice guy. I really do like Tim. Okay, so what are the facts of this case? So everyone probably in this room is familiar with SolarWinds at this point. But essentially what happened in SolarWinds is there's a vulnerability in SolarWinds. They announce it. Everybody goes out trying to patch it. And there's an SEC investigation that follows. And the SEC's investigation is focused not really on whether SolarWinds was a bad product or not, whether or not it had a vulnerability or not. It's whether or not the company disclosed information that shareholders needed, or whether they lied to the public. There's a common theme, by the way, in some of these cases. It's really about transparency and what the government expects to do and what your obligations are to do. So we've been having this fight with the SEC ever since I represented the CISO at Yahoo years ago when we were fighting about this with the SEC. But they decided to take this action and go forward. And what they've basically done is they've alleged, this is really tiny print, but they've alleged, so I'll just read it real quick so people can see it. They've alleged that there was misleading risk factors because there were deficiencies in the controls that made SolarWinds, quote unquote, very vulnerable or at an increased risk of attack. Public statements to customers on its website, right? So these are statements that Tim made or attributed to Tim that the company made about security, right? Misrepresented security policies. The ultimate allegation, SolarWinds lacked reasonable controls for escalating potential material incidents, for restricting assets to its most critical assets. SolarWinds then files a motion so this investigation went on for years. And then what ultimately happened was the SEC decides it's going to file an enforcement action. They file an enforcement action, which means they file the complaint in court. They charge the company and Tim, nobody else, with basically misleading the public, shareholders in particular. SolarWinds and Tim moved to dismiss. This is a little old, right? So what happened was the SEC then amended their complaint, and then they filed another motion to dismiss. But ultimately, the defenses are largely the same. Thank you. SolarWinds says, look, the risk factors, right, the sophisticated nature, that's all in our 10K. We disclosed all of that. We said the product's not perfect, right? No reasonable investor would believe SolarWinds' statements of implied perfection. The risk factors clearly warn that it's vulnerable. So when you look at the complaint and all the bad things the complaint says, the motion to dismiss says, no, we said all that. Here's where we said it all. So the argument ultimately is, like, did they say enough? Did they tell a half-truth? Did they not tell a half-truth? Some of you may have looked at the recent Supreme Court decision of McCrary and say, does this impact this case? Probably not substantially, because that's just a question about omissions. So if you want to talk about McCrary, I'll talk about that afterwards. But ultimately, where we are is that this is going to be a tectonic fight, right? And it's going to set the standard for what do companies actually have to disclose in their risk factors to protect against these harms. So on the other side of the fence, how are we all looking at it as lawyers is we're all looking at it and saying, are you crazy? Now what do we have to actually say? So we're looking at the disclosures that SolarWinds actually made. We're looking at the allegations in the complaint, and then we're asking ourselves over here, okay, what in God's green earth do we have to say? What is necessary to disclose in order to make the public aware of that risk in a sufficient way to protect you? So that's why this case matters. So if you're in a public company and you're looking at the risk factors, right, this case teaches lessons about what is or what is not enough, at least what people are arguing about. We think a decision will come out in the summer of 2024, maybe a little bit later on that, but this is going to be, when it comes out, a really important watershed for everybody who sits on the cyber side, on the disclosure side, and on the security side to try to figure out, what do I have to say? And the last thing I'll say about this, and I'll get to your question in a second, the last thing I'll say about this is, this was not all about statements in 10Qs and 10Ks. This was about statements that they made to the public, right? Like on a blog, on their website. And those have all of a sudden become actionable is a grand departure from all the other SEC enforcement investigations that we've been involved with. Okay, over here real quick, and then I'll pop around. Yeah.
Yeah, just looking at this, isn't this similar to the case between the FTC and Wyndham Worldwide?
How so?
Well, it was a violation of Section 5 of the Act, right?
Right.
And the argument from the FTC was that Wyndham, right? You get what I'm saying right now.
I do get what you're saying.
Right.
So I think there are some similarities, right? Again, I think you sort of seized on the theme. There's some similarities between what the government thinks that companies should be disclosing and what we think we need to disclose and what too much disclosure is, which actually undermines the whole priority of what we're trying to do.
I mean, I'll be surprised if I'll bet that the SEC is going to sustain the motion to dismiss, because if they're very similar, the Second Circuit has already ruled against them in that. Very likely.
I'll take that bet. The SEC is going to keep their complaint. That judge is not going to dismiss that complaint. The government almost never loses.
Yeah, that's what I'm saying.
You're saying, okay, yeah.
The SEC is going to sustain the motion
the
to
words
dismiss.
that they're going to overrule the motion to dismiss. Yeah. They're going to sustain the complaint. I think you're right.
So the key word that stands out to me on this is the word material, right? So what's material to my organization might not be what's material to another organization. How closely are the regulators monitoring and trying to level that playing field?
If you can define materiality, there is a giant pot of money in the sky. The reality is that materiality, this is the Supreme Court has defined it as like, what would a reasonable investor actually care about? Basically, right? Nobody wants to actually define it. Lawyers want to have the ability to argue one way or the other. The SEC wants to just say, well, your stock price dropped by $3. That's material. So this is always going to be a fight. The problem is you can't do it at this stage in the motion practice. So just procedurally for lawyers, that's not the time when we're going to attack this. That comes later, right? I'll just say, we always fight about materiality with the SEC. And the SEC will always make up some argument, and it's a really difficult place to win your argument, right, in terms of what is or what is not material. So just as an example, one of them is whether they actually followed a secure design process in building solar winds, right? And they say they did, and then if you look at like internal documents, like we're not really doing this, right? Like we're not following our policy, we're not actually doing secure life cycle design, right? And so that's part of why they're saying it's false. So that after an investigation, they had that evidence of like emails, which like you can believe what you want to believe. Some would say they're cherry picked, some say there's a lot more like it, but they picked those emails and said, which are internal emails saying like we're not really doing what we say we're doing. Yeah.
I won't attribute the exact person, but he went to the Congress panel right after this happened. He basically said this is what happens when financial people take over companies and don't invest in technology.
What he's saying is that there's some commentary. I think it's a little cynical, but I think I think you know that. This is what happened when financial people take over a company that's actually doing security. I don't know if I have an opinion on it or not, but talk to a PE firm and ask them what they do. Okay, I know I'm running out of time. We have a couple more parting shots, so I'll give it back over to Ray.
Okay, do we still have the slides? Or?
Yeah.
Okay, there we go. So just a few cases to watch. That first case, there are some people who claim that it is the most consequential, potentially the most consequential case for cybersecurity. Doesn't even deal with cybersecurity directly, but Relentless versus Department of Commerce basically is ruling on something called the Chevron deference. Chevron was a case where it said basically the courts should generally give deference to an agency that is interpreting a law to make regulations. In some cases, agencies have started regulating cybersecurity. For instance, the Environmental Protection Agency, the EPA, they have found out that water systems are being cyber attacked. And that in some cases, those attacks can undermine the quality of the water that's delivered to the public. So they tried to start issuing regulations about cybersecurity of water facilities. Some of those facilities pushed back. Eventually, there were judgments against the EPA, so the EPA basically lost that authority based on some lower court rulings. They lost that Chevron deference in that area. And what they did is they actually shifted over to CISA. So now CISA is starting to introduce some of those types of policies. But the question is this broader than that? And that's what the Supreme Court's going to be basically reviewing here. They're going to review to what extent do courts have to give deference. The argument being made by one side is that when Congress makes laws, they're acting in their statutory authority, their constitutional authority rather, to legislate. The executive branch is not supposed to legislate, and Congress can't delegate legislative authority. On the other hand, some people are saying, look, Congress can only make so many laws, and they can only do so many things. To make the Constitution workable, they have to delegate with some discretion, certain areas, and that agencies who have the expertise in those areas should be able to fill in the blanks. So those are kind of the competing arguments. If the Supreme Court kind of does away with Chevron deference, it could mean that agencies will no longer be able to issue these types of cybersecurity gap fillers. And if they can't, we would have to wait for Congress to individually legislate in each of these areas and try to keep up with the technology. You can see why that might be bad for cybersecurity. Missouri v. Biden, we don't really have time to get into a bunch of these. So State v. Valdez basically just dealt with some Supreme Court, Utah Supreme Court regarding cell phone passwords. There's kind of a split still in what those are. That particular court held that it's a Fifth Amendment violation to demand the password be revealed. Sometimes it's brought up in Fourth Amendment cases, sometimes Fifth Amendment, so we're kind of going back and forth there. There's basically two ways that can be done. They can either say, give me the password, that's what was done in the Valdez case, or they can say, don't tell me the password, just type it in, decrypt your device, and then give me the decrypted device. The courts have dealt with those somewhat differently, but they've held them in both ways on both sides. So eventually the Supreme Court will have to decide this. There's pretty much a split in the circuits right now. Whoops, there's our apply slide. We don't have time to get through it in detail, but I think both Arvin and myself, we tried to give you all the applies along the way. So if you missed any of them, here's a quick summary of what you should do when you get back to your workplaces. Any final questions? Okay, thank you very much.
Thank you.